So the importance of funding, what happens without it, a completely unfunded trust. So again, the box had been closed and sealed up because you went to the estate planning attorney, or maybe you filled out a little form online, you got a trust, you executed, you got it notarized, you got a really pretty binder, and you stuck it up on the shelf. Again, that's the empty open box. But you didn't realize that you had to fund that trust, that you had to change and transfer assets into that box. So after the box closes, the trustee opens it up, and lo and behold, nothing's actually inside the box. It's actually all outside of the trust, okay? Outside of the box. So we're looking at having to go to probate court for one thing or another. It could be up to 5% of the gross estate in fees and costs. Estate taxes come out if any are due at that point. And then whatever's left over will go tax-free to the beneficiaries. So a fully funded trust is really the key to success. If a trust is fully funded, so that's why I say a fully funded trust can avoid probate. An unfunded trust will most likely not avoid probate, okay? Or some type of, there will be some type of administration or some type of proceeding in probate if the amount is over the small estate exemption, which is, I think in this year now, we're looking at a little bit over $200,000 right now. Okay. So a fully funded trust, we avoid probate. Taxes still have to be paid if any are due over that $13 million exemption. And then whatever's left over will go tax free to your beneficiaries with whatever protections it is you've built in for them. Okay. So what is the real cost of not funding your trust? So accessing assets during your disability. The example here is you've been deemed mentally incapacitated. Your disability panel has been convened. They realize you're writing those checks of $5,000 to the guy in Jamaica to get the lottery. And so it's looking like your kids need to access your investment account with Charles Schwab that is just in your name alone. And this, I see this happen not only in for people that are single, but even married couples where maybe there's one spouse who is doing all the investing, and typically it's only their name on that account. Okay, and perhaps they've not named a transfer on death beneficiary. So now, I'm sorry, a transfer on death beneficiary is not going to help you in this circumstance because you are still alive. Okay, this is during your mental disability or mental incapacity. But your kids need to access your investment account for $200,000 to be able to pay for your care. So, who can access it? Well, if you had funded it prior to you becoming disabled, it's very easy. The mechanism is set up in the trust for your disability trustee to access it. They do it through what's called a certification of disability, and it's just done at the attorney's hourly rate to prepare that. If the asset is unfunded, one of the things that can be used is what's called an agent for power of attorney under a power of attorney. The problem is that many financial institutions don't honor durable powers of attorney. It is the number one tool of abuse that is used by financial abusers. Because of that, and because banks are mandated reporters in financial institutions, they're trying to find a way to reject powers of attorney because they don't want to be in the hook for helping somebody get access that really shouldn't be getting access. So what they do is they say, well, it is our own internal policy that a durable power of attorney must be executed on our forms within the last 6 months. It's pretty ridiculous. You're not going to run around and get that. And so on that grounds, what they'll do is they'll say, we're not going to give you, child, access to your parents' funds, even though we know that he needs it for his care, until you go and you get a court order showing us that you are the right person to have access. So what you would have to do is file for conservatorship. You're going to access that through a court order, and the cost for that is $5,000 to $8,000 for the initial petition. That's just an estimate, and it'll be over $2,000 most likely per year in the subsequent years for accounting. So this is really the real cost of not getting your assets into the trust. So what happens when you die? So let's say you've passed away and you have your house that you just never got around to putting into the trust. Perhaps it's a new rental property you purchased. Maybe I do even see this in spouses where maybe only one spouse was available for purchasing that property. So their name is the only name on the house and they don't get around to updating and making sure that title to the house is transferred into trust. So the house, let's say, as of date of death, is worth $500,000. If you have properly funded that asset to the trust while you're alive, and you do that through using a grant deed, transferring the title to the trust, it'll only take your trustee. They can pretty much access that immediately after death. The cost to fund that asset to the trust through our firm is $300 plus recording fees. Okay. If the asset is unfunded, we can do, again, like I said, if you don't get the assets into that box prior to you passing, typically we're going to be in probate court in one way or the other. So we can file what's called an 850 petition with the probate court after you've gone. It can be anywhere from 4 to 7 months after filing the petition or longer, depending. Right now, Placer County is pushing out initial hearings, I think 5 or 6 months out. So it's pretty crazy. But the cost to fund that asset anywhere from $4,000 to $6,000. Or, and if you're unsuccessful in that petition to try to get it into the trust, you will have to file your loved ones will have to file for a full-blown probate. To go through the entire probate process, it's going to take over a year for the filing of the petition and distribution of the assets. And those assets would then, it could get poured over into your trust, but the cost for this is very expensive. That's $26,000 in attorney's fees and personal representative fees, and these are set by statute. So the attorneys would get $13,000 and the administrator would also get $13,000. So looking at that last row, it's really important to make sure that you take your steps to look at getting your assets, especially your house, funded to the trust. One one thing to take into consideration, if you are doing refinances, many times the lender will take the asset maybe outside of the trust, put it into your own name, write the loan, and then they tell you they'll put it back into the trust. So sometimes that doesn't happen. They don't put it back into the trust, or maybe they put it back incorrectly. So that is definitely something, if you've refinanced in the last however many years, if you already have a trust, that is something that you definitely want to check, is what is the current status of title to your house. So